If you are a wife, if you are a girlfriend, if you are a woman, take keen interest in this explainer number 6. How will your land be registered before yours truly dies? If you want to ensure your land he has bought you, or you have taken a loan and you have given him, the land should not be registered in his name. If it is registered in his name, it will go to succession. But you remember, when succession comes, you thought you are the only one. You get there are 20 women with 50 kids. No father has war with the children. Fathers want the children to inherit when they die, unless the wayward children. No mother has war with their kids. They will want when they die, the kids take those property. The war is between the father and the mother. So if you have a dispute and you don't want your man, you don't want your woman to inherit the property because you think if you die, she can be married, she can kill you. You have your 4 kids. Register your property jointly together with your children. The law allows the title deed to have as many owners as possible. Welcome to Court Helicopter Explainer, episode 6, on the question of Land Act. We are dealing with the Land Act, 28 episodes. We are now on episode 6. This is about the transmission. Do you know what is transmission? We have dealt with the transfer of land. The difference between transfer and transmission is that the transfer, the person transferring the land is the owner, but he's alive or she's alive. Transmission, it is the owner, but that owner is dead. The law transfers his or her property when this person is dead and has been buried. That is what is called transmission. So don't tell me that you can transmit your land. You cannot. You can only transfer your land, but you cannot transmit your land. So the question now comes, the land that is being transmitted, the question that is there is, how was it registered when the owners were alive? Some lands are registered as a sole owner. The title belongs to Vivian Navete. That's the sole. The property can be registered jointly. And this is the most critical episode for wives. If you are a wife, if you are a girlfriend, if you are a woman, take keen interest in this explainer number 6. How will your land be registered before yours truly dies? If you want to ensure your land he has bought you, or you have taken a loan and you have given him, the land should not be registered in his name. If it is registered in his name, it will go to succession. But you remember, when succession comes, you thought you are the only one. You get there are 20 women with 50 kids. Under the law, the land law, section 49, it is called transmission on death of joint proprietor. If one or two or more joint proprietors of land, lease, or charge dies. You can own your land with your husband jointly. If you are a girlfriend, you can own the land with your man jointly. 2 names on the title deed. Yours and his truly. If he dies, what does the law say? The registrar of lands shall, read that, the registrar of land shall, on proof of yours truly's death, delete the name of yours truly, the deceased, from the register by registration of the death certificate. There were 2 names at the title deed. Yours truly, Shadrach Wamboi. And you call yourself Mary? No. Not Vivian, I know Vivian. You oh, Nyambura, okay. Atieno, yes. You woman. Your husband or yours truly, your boyfriend is Shadrach Wamboi. Shadrach Wamboi is dead. The name in the title deed are 2. The registrar, you only need to carry a death certificate and tell the registrar, yours truly Shadrach is dead. The registrar will take a pen and delete Shadrach's name, and you remain the new owner of that title. There'll be no going to succession. There'll be no people fighting that they were children or offsprings of yours truly. That is the position of the law. 2, what if it is a proprietor, a sole in common, ownership of land in common? Section 50. If a sole proprietor or a proprietor in common dies, the proprietor's personal representative shall, on application to the registrar in the prescribed form and on production to the registrar of the grant, be entitled to be registered by transmission of that. If it is your husband who is the only person registered, you must go to succession. After you have gone to succession, you have fought those quacks, you have fought those women, you have fought those children, you get a grant that you are the one. Then you will take that grant to the registrar. Then the registrar will change the title deed from your father, from your husband, from your whoever it is, to you. This is a very risky way of ownership of land. Let me give a sound advice. If you are really in love of your children, why don't you register the properties in the names of your children jointly with you? If you die, those children of yours will get that title without other children, surrogates outside. If you hate their mother, but you love your children, register jointly the properties in the name of yourself and your children. Let us look at the authorities, because this is the most fundamental episode. Number 6. We look at the authority, succession course number 2 of 2024 in the High Court at Busia, Justice William Musyoka J. The decision of June 18th, 2025, in the matter of Samson Obombe Anyimo, deceased. This is a very, very important authority for women and for children in this country. Paragraph 15. A certificate of confirmation of grant has no life of its own. It is a court paper extracted from the court orders on confirmation of grant of distribution. This is land registered in common or in the name of the father alone. The court order on confirmation of a grant or distribution is the foundation for the certificate of confirmation of grant. And once the distribution of the confirmation orders are vacated or set aside, the certificate of confirmation of grant becomes a useless piece of paper. What is the judge saying? You can go to succession and you get a grant. 10 years, a woman comes from Tanzania and says, I have since discovered my husband died, he had 2 children. They file objector proceedings to revoke the grant. If the succession is proceeding, they'll file what is called objector proceedings. If the succession has been done and the grant has been given, they will come to what is called an application for revocation of a grant. The grant will be revoked. The people you sold this land, you'll have to refund them their money. That is why I'm telling you, ensure, as a woman, any property bought to you, whether it is a Vitz, an Uber, a car, let it be registered jointly. What does the judge proceed to say? He moves on to say, the certificate of confirmation of grant is the basis for the transmission of the estate. It is the document required by the Land Act and the Land Registration Act for transmission purposes. Land legislation requires the land registrar to transmit the estate upon receipt of that certificate. Without it, there can be no transmission. The transmission process becomes invalid upon the distribution or confirmation orders being vacated, for it loses its foundation or legitimacy thereby. The consequences of vacating or setting aside of orders on distribution or confirmation is the invalidation of the certificate of confirmation of grant and the transmission of the estate based on. So the judge is saying, your grant, once it has been revoked, any other transactions that were there, any title deed that was issued is nullified. It becomes a mere paper. The judge is not hostile. The judge is telling you the truth. Paragraph 18. The process of transmission of the estate of a dead person is not a succession process. Mark the words of the judge. The process of transmission of the land from the deceased person to you is not in the succession court. The succession court finishes with saying, Vivian, we give you the grant for this land. You move to the Land Act. That is where the interface now we are bringing you why succession ends with the Land Act. It is founded on the orders of the probate court on distribution, as detailed in the certificate of confirmation of grant, but that does not make it a succession process. The role of the succession court under the Law of Succession Act, Cap 160, essentially ends with the orders on confirmation or distribution. The actual distribution is what is called transmission, which is provided for under the Land Act and the Land Registration Act. Transmission of land upon death is a land registration process governed by the land legislation and subsequent upon completion of succession process. The Act says nothing about transmission. Indeed, the word does not appear anywhere in the Law of Succession Act. That should explain why the probate court does not usually make consequential orders relating to the transmission process once it sets aside its orders on confirmation or distribution. This is the most important authority for women. And very many of you have done succession. You have the grant. It ends there. How many of you are keeping grants under the lock and key, under the safe, under the coat, and in your bag as women? You must move to the next stage, to the lands registry under section 49 and section 50 to do what is called transmission. If ulilalia masikio, you are not jointly registered as the owner, but you have miraculously survived in the succession court and you have the grant giving you that land, you must go to the land registrar. The land registrar will now implement the grant that you have and transmit that land to you, and a new title deed will be issued to you. Don't argue about land ownership at the succession court. But to me, the biggest lesson is that whenever you are given land, if you are a wife, insist on that land being registered jointly with your wife, your husband. If you are a woman and land has been bought, insist on that land being registered jointly together. Vivian has been called and people are shouting at her that, do you know that is a cause of death? If a woman knows you have registered land jointly, and if you die, the land goes to that woman, do you know it is the cause of death? Yes. I'm a criminal practitioner. I defend people who have been arrested and charged for murder. Some of them murdered because the properties were registered jointly. True. Insurance premiums. People fear to take insurance premiums because if you take a life insurance cover, your wife or your husband can kill you to get that. But under the law of succession, which we did, if you kill somebody for the purpose of inheriting that land, you lose. No father has war with the children. Fathers want the children to inherit when they die, unless the wayward children. No mother has war with their kids. They will want when they die, the kids take those property. The war is between the father and the mother. So if you have a dispute and you don't want your mother, you don't want your woman to inherit the property because you think if you die, she can be married, she can kill you. You have your 4 kids. Register your property jointly together with your children. The law allows the title deed to have as many owners as possible. If you are a mother and you fear your husband is a demagogue, but your children are good and you bought property, register that property together with your children jointly. Don't put the devil in the name. The devil can be the husband, the devil can be the wife. But my advice, your children love you. You love your children. So the law is very, very clear. But for women, listen to this clip, share it widely. Let not you be cheated that this property, let it be registered in my name. Even if I die, you have my marriage certificate, you'll inherit this land. Insist on that property being registered jointly. Wakili Danstan Omari, courtesy, Visa Authority. Vivian had to go to Busia to bring it. We acknowledge her contribution and her research. Asante sana. Let us go next week. Episode 7 to 13. Next weekend. Don't miss it. It is our pleasure to bring you the law, the authorities, and how the courts have decided and how they have interpreted both sections of the law. Thank you.